This is Duke University.
Pizza, that's fine, just do it quietly. Thank you guys so much for coming this afternoon. I think this is going to be a really exciting talk, and we've got some great speakers here. This talk was put on by the Intellectual Property and Cyber Law Society in partnership with the Center for Law, Ethics, and National Security. So we thank them very much for their help, and thank you guys all for coming. If you guys don't know about IPCS, you can check out our website. We're going to have elections coming up next month for our executive board next year. My name's Nicole Landguth. I'm the director of cyber law for this year. So that's where my interest in this topic kind of came up. And what I'm going to do is, just for the 1Ls in the room and people who didn't do moot court last year, I'm going to run through really quickly the facts of the case of Jones v. United States, just so we're all on the same page about what happened and the panelists don't have to re-explain it. Okay, so it's all about the Fourth Amendment. If you guys don't already know it by heart, the right of the people to be secure in their persons, houses, and papers and effects against unreasonable search and seizures shall not be violated. This is about the unreasonable searches part, not seizures. The main test before United States v. Jones was from Katz v. United States, where someone's conversation was bugged while they were in a telephone booth, a public telephone booth. And the test that came out of there from Justice Harlan's concurrence was that a person should have, that for a right to be violated, a person had to have exhibited an actual expectation of privacy, and that expectation was one that society considered to be, quote, reasonable. And then this case comes up in, it was argued in last year, and then the opinion came out in January. This is Antoine Jones. He's a nightclub owner in D.C. If you guys are from D.C., he owned Fur Nightclub, if you're familiar with it. And the FBI had a warrant to track his car with a GPS, but it was only for the District of Columbia, and they did it when he was in Maryland, so that's why they didn't have a warrant to put a GPS on his car in Maryland. So they put a GPS on his car, tracked him to several different drug dens and drop-off places, and then his case was eventually thrown out because the court ruled that the GPS tracking was contrary to the Fourth Amendment. And a couple of the choice quotes from the opinion. This is from Justice Scalia, who wrote the majority, or plurality, the majority. He came up with this new test that we're going to apply what the 18th century founders of our country and authors of the Constitution would have believed to be an unreasonable search and seizure, and what would have been trespass in that time. And Sotomayor filed a concurrence in the opinion, but she pointed out, what are we talking about, this 18th century trespass stuff? We need to talk about the digital age. People have different expectations of privacy, and we need to figure out if the Katz test is still a good test. And then Alito filed a concurrence in judgment. I just pulled this out because I thought this was probably the funniest Supreme Court footnote I've ever seen. He talked about the 18th century, and he said, "It's possible to imagine a case in which a constable secreted himself somewhere onto the coach, remained there for a period of time in order to monitor the movements of the coach's owner." And then the footnote is, "The court suggests something like this may have happened, but it would have required either a gigantic coach, a very tiny constable, or both, not to mention a constable with incredible fortitude and patience." And then this final quote that you guys probably saw on the posters to this event, that the Katz test rests on an assumption that this hypothetical person has a well-developed sense of privacy. But that's changing, so that's what we're here to talk about today. And without further ado, I will turn it over to Professor Jennifer Jenkins, who's going to moderate the panel.
Thank you, Nicole. And good job, Nicole, and the IP and Cyber Law Society for putting together this fascinating event. As moderator, it's my pleasure to introduce our three esteemed panelists today. Just to my right is Professor Sarah Ludington, a proud alumni of Duke Law School, and current assistant professor of law at Campbell University Law School in Raleigh. She taught information privacy in a seminar here at Duke Law School, and her scholarship focuses on the areas of privacy and academic freedom. We'll hear from her first, and then following her will be Major General Professor Charles Dunlap.
A legend in my own mind.
Who many
I want
of
that
you
clear on the record. Did we
may
get that
know.
recorded?
He is visiting professor of the practice of law and also executive director of the Center on Law, Ethics, and National Security that's co-sponsoring this event. He is the former Deputy Judge Advocate General of the United States Air Force. I
found out two
I
things.
cower.
Two things. Number one, I can't run like these guys do. These guys are freaking marathoners, and it's a
Half
little
and
bit
half.
scary.
But she's a marathoner. I believe.
And let me tell you something. I can't eat like him. Even on my best day, I can't eat like him. So
But he can force the lights to turn off by the simple act of speaking, which is quite impressive. Professor Dunlap's teaching and scholarship focuses on national security, international law, civil military relations, cyber war, and military justice. And last but not least, many of you know Professor Stuart Benjamin, who is the Douglas B. Maggs Professor of Law here at Duke Law School. He specializes in telecommunications law, First Amendment, and administrative law. Before he began teaching law, Professor Benjamin clerked for, among other people, Justice Souter of the U.S. Supreme Court and worked as an attorney advisor in the Office of Legal Counsel in the U.S. Department of Justice. So these are the panelists that we get to hear from today. I am excited about moderating this panel because I think it touches on some very important and very fascinating issues that are especially pertinent to everyone in this room. So I want to frame the discussion by just briefly touching on three themes that will come up during the discussion today. The first relates to what Nicole just showed. It's the constitutional theme, namely that the protection for privacy under the Fourth Amendment is tied in part to the actual and reasonable expectation of privacy, which is in turn linked to commonly available technology. And as the quotes from Sotomayor and Justice Alito pointed out, this technology is rapidly changing and becoming ever more intrusive. It's not just GPS tracking in your car, tracking in your phone, huge databases of data from your bank, your credit card, your phone records, all of the images from ubiquitous cameras and satellites. Virtual searches have replaced physical ones. And so the question is, to what extent does this mean that the protection for privacy in the Fourth Amendment is itself eroding perhaps more rapidly than ever now and even in danger of becoming obsolete? So that's the first theme. The second and related theme deals with pervasive practices of data mining and aggregation by both state and private entities. So I don't know if you saw, there was a recent article in the New York Times about how the retailer Target aggregates its customers' data to find out all sorts of interesting things about them. Among them, they like to find out that customers are pregnant before they actually have their babies. Why? Because when you have a baby, apparently your shopping habits become in flux, and it's a gold mine for retailers because if they send you the coupons you need, you're going to go and buy everything from, for example, Target. And Target's data crunching is remarkably accurate. They've been able to predict with some accuracy and deliver targeted coupons to, for example, a teenage girl whose father found that she was getting coupons for baby clothes and cribs in the mail and went angrily into Target and said, "What are you suggesting? Are you trying to, suggest that my daughter should get pregnant?" And then a few weeks later he called and he said, "Well, I guess there's things in my house going on that I don't know about." She's due in August.
keep those coupons coming.
Yeah. So to what extent does this kind of data mining and aggregation by state and private parties go far beyond the bounds of legal protections? And this is your data, this is my data, that we currently have in place. The third and final theme ties into national security, something that Professor Dunlap is going to talk about. There are a lot of studies on this. I'm going to reference a 2010 recent study called Top Secret America that was done by the Washington Post that discussed a vast and unwieldy intelligence apparatus at local, state, and federal levels involving almost 3,984 federal, state, and local organizations. You can actually go to the article and search their database for information about what's going on in North Carolina. And these databases aggregate private data together with publicly available data. And the question is, to what extent is the law responding to this kind of threat to privacy, privacy intrusions in the important interest of national security? And how do we ensure that we have safeguards to maintain both privacy and national security. So I just wanted to identify those three themes, and without further ado, turn the podium over to Professor Ludington.
Oh, thank you all for coming. Thank you, Nicole, for organizing this. I want to talk about two aspects of the opinion in U.S. versus Jones, and specifically Justice Alito's argument that the decision in Jones really should have rested on the Katz opinion, not on the trespass analysis in Scalia's opinion. And second, Justice Sotomayor's comment that the Supreme Court should really consider overhauling the third-party doctrine in the Fourth Amendment. So, first of all, Justice Alito, argued that the decision in Jones should have rested on the reasonable expectation of privacy test from Katz. And while I largely agree with Alito and with Justice Sotomayor, I am a bit skeptical, perhaps, that the Katz test really provides strong protection for privacy when dealing with new and emerging technologies. There are obvious problems with the Katz test. The first one being it can be criticized for being overly subjective, right, and therefore unpredictable, right? This is private because I think it's private. It also sometimes appears when you're reading the opinions that the privacy expectations of federal judges are actually the only ones that society is really prepared to recognize as reasonable. But the most problematic aspect of the test, I think, is that it's really vulnerable to the vicissitudes of changing social attitudes towards privacy. And as noted in the opinion, when a society has well-developed and stable set of privacy expectations, then Katz it works well. For example, the landline, which has been a stable technology for a century or so, is very well protected by Katz. But when technology changes, and particularly at a rapid rate, it can produce significant and really uneven changes in popular attitudes towards privacy. And certain segments of society may adopt new technologies, and they're happy to make the trade-off from utility to the detriment of their privacy. Other segments lag behind. They might not like or understand the new technology, or indeed might be more cautious and reluctant to compromise their privacy. So what happens to this world in flux where expectations of privacy are in a sense struggling to keep up with new and emerging technologies? Not surprisingly, society itself and law enforcement and judges can all get confused about what the expectation of privacy is or should be. So, just to try to illustrate some of the complications, judges currently decide as a matter of law whether a defendant has a reasonable expectation of privacy, and judges tend to reason from principle and precedent rather than, say, relying on evidence or empirical evidence of what societal expectations of privacy actually are. Principle and precedent, of course, might not supply adequate grounds for making a decision where a new technology is involved. Judges sometimes don't understand the new technologies. And this, I think, partly explains why some of the Supreme Court opinions about the reasonable expectation of privacy have been criticized and demonstrated, actually, to be out of step with commonly held attitudes about police investigative techniques. So some people, what's the solution, right? Some people have suggested judges should really rely more on empirical studies about actual privacy attitudes. So in Jones, for example, Justice Sotomayor sort of signals that she's open to considering empirical data. For example, she writes about the way that GPS technologies now record and aggregate location data, and she questions whether, the millions of people who have adopted this technology are really prepared to accept that the police can now collect information and aggregate it, collect information just about the movement of their car that might reveal their political and religious associations, their health problems, their sexual habits, and so on. So her implication, of course, is that if there was some empirical work showing that people were really not prepared to accept this kind of police surveillance and data aggregation, then the Fourth Amendment should offer some protection. But it's not always clear, to me anyway, that relying on empirical studies will make the analysis, the Katz analysis, more accurate. Empirical studies about expectations of privacy don't map easily onto this idea of a reasonable expectation of privacy because attitudes towards privacy are complicated and difficult to untangle. So, just to give an example, most of you all, the under 24s in the room, it's pretty common wisdom that all of you have abandoned your expectations of privacy in favor of exploiting social networking technologies, right? However, empirical studies that have analyzed attitudes towards privacy have shown that actually under 24s are really quite similar to their older counterparts in their attitudes towards privacy. So both groups, or all groups studied, seem to desire and value privacy quite highly, even though under 24s are more willing to share personal data online. So what explains this seeming contradiction, right? An increased willingness to share data, perhaps you could even call it data promiscuity, but yet a professed valuing of privacy. Well, the same study that looked at privacy attitudes among different age groups also revealed that under 24s are, I'm sorry to say this, significantly more ignorant of privacy laws than older Americans. Now, older Americans, by the way, are also woefully ignorant of privacy laws, just less so than younger Americans. So the hypothesis put forth by this study is that younger Americans are more cavalier about sharing their personal information, in part because they wrongly believe that there is a robust legal regime out there somewhere that will actually punish or hold people accountable for misusing their personal information that they share so willingly. So, how could a judge use this empirical study, say, to translate into a reasonable expectation of privacy in the Fourth Amendment context? Should our reasonable expectation be measured by the attitude, privacy-preferring attitude, expressed by a wide swath of Americans? This would suggest strong Fourth Amendment protection for electronic data. Or maybe should our reasonable expectation of privacy be instead based on that contradictory behavior and the promiscuous data sharing that not just younger Americans, but really many Americans engage in through all the various technologies that are available to us? Or perhaps the judge really should rely on the optimistic, widely held, but manifestly incorrect belief that there is a legal regime that protects privacy, because this shows, that society really is prepared to accept as reasonable a robust robust privacy interest in data, even if we're prepared to accept it, even if we're wrong that it exists, right? So, to summarize, I agree with Alito and Sotomayor that Katz really is the better approach rather than the trespassery approach. But it's really not clear to me that the Katz standard is an easy or clear solution when social attitudes towards privacy are in such a state of flux. So my next point, in Jones, Justice Sotomayor signaled that she was willing to entirely reconsider the third-party doctrine of Smith versus Maryland. And the third-party doctrine essentially holds, it's another aspect of Fourth Amendment law, that a person has no legitimate expectation of privacy in information that he voluntarily turns over to a third party. And that third party might be a police informant, it might be an unfaithful friend, it might be your bank, It might be the telephone company. So the justification for this doctrine is that a reasonable expectation of privacy, to a certain extent, has to rely on the defendant actually trying to keep certain information secret. And as Justice Sotomayor noted, and it was on one of the introductory slides, this doctrine is particularly ill-suited to the digital age, where people reveal a great deal of information about themselves to third parties in the course of really carrying out very mundane tasks. So we tell Time Warner Cable the URLs of every website we visit. Time Warner Cable knows the emails of everybody we send an email to. We tell Amazon what books, music, videos, clothes, what have you, we purchase. And even if you don't purchase online, if you belong to any kind of a customer loyalty club at a bricks and mortar store, that retailer keeps a detailed record of everything you've purchased, at what date, at what time. If we use cloud computing, such as iCloud, we share all of our work and personal electronic files with that data service, including possibly a lot of, First Amendment sensitive material, photographs, music, things that really reveal our protected speech. And if we own, say, for example, a Chevy, or perhaps a GPS-enabled phone, we reveal our location data every day, everywhere we drive, to GM, and also to our cell phone providers, and potentially to every social networking site that we have linked through our phone. So Jones would have been a completely different case, for example, if he'd owned a Chevy. The police would simply have been able to subpoena his location data from OnStar. They wouldn't have had to worry at all about affixing a GPS device to his car or about getting a warrant. But this brings us back to Justice Sotomayor's question, should using this technology mean that we must relinquish all expectations of privacy in that data as against a government search? Justice Sotomayor clearly thinks it should not. She said she wouldn't assume that all information voluntarily disclosed to some member of the public for a limited purpose is, for that reason alone, disentitled to Fourth Amendment protection. And I haven't seen much empirical work on this yet, in fact, any yet, but certainly about GPS location data. An anecdote I can think of that seems to confirm Justice Sotomayor's opinion was last year when it was revealed that the iPhone collects detailed location data about the phone that it's stored in a file in the phone for up to a year. All right, and there was pretty significant consumer pushback against this kind of a file being kept in the phone, despite that so many people really love and appreciate the GPS technology that comes, the location technology that comes with so many smartphones. So my point here is that really, I think Justice Sotomayor is onto something. I think that eliminating the third-party doctrine might be an innovation in Fourth Amendment law that would really provide quite significant protection for data privacy, given the current direction of emerging technologies. So one concluding point, the narrowness of the holding in Jones makes it pretty clear that the federal courts are going to be revisiting this geolocation question sooner rather than later. But rather than placing the decision entirely in the hands of federal judges, I really think it's advisable for legislators to enact stronger privacy laws. Legislation is obviously not a perfect solution. Statutes will inevitably lag behind technological innovations and require frequent amendments to stay up to date. But they're useful in two ways. Statutes are useful in two ways that I'll mention briefly. First, statutes can be enacted as technologies emerge, and an example of that might be the Electronic Communications Privacy Act, which was enacted in 1986 to protect email at a time when I think it's safe to say most Americans had no idea what email was, all right? And that legislation was passed basically at the time that email was emerging. And this this eliminates the really significant lag time that often occurs between the emergence of new technology and when a federal judge actually decides the case. Second, legislation can actually construct an expectation of privacy where none exists. So under current Fourth Amendment law, we have no legitimate expectation of privacy in much of the data that we share with third parties. But a law that gave strong protection to location or GPS data, for example, it would create a bulwark against police aggregation and or exploitation of that data. But it also gives credence to the argument that we have a legitimate expectation of privacy in data that we create in public and willingly share with third parties. So in short, I think if we value our data privacy, we really need the legal regimes that our 20-somethings think we have. So.
Thank you very much. That was really a great disassembly of the Jones case and analysis. What I'd like to do is I just want to speak for a few minutes because I really do want to get to the questions. A lot of times in these things, the student questions are the most interesting part. But I'd like to underline a few things. Number one, you really need to read this Jones case if you haven't. If you don't read any other Supreme Court case that isn't actually assigned, this is probably the one you want to read. And I think it's only 34 pages, so it's not that bad. Especially, I think Sotomayor's concurrence is because she raises all the important questions. I just want to make the point that we need to consider that in the post 9/11 world, there's an awful lot of technologies that have been developed that allow the surveillance of people in ways that just 10 years ago would have been unthinkable. We're seeing part of it here with GPS, but now we have domestically used drones, and we have the capability to intercept phone calls, emails, everything else. In the article that was mentioned, Top Secret America, they make the point that the National Security Agency every day collects and stores 1.7 billion emails and phone calls. And that gives just a tremendous capability. And recently there was a memorandum of understanding between NSA and Homeland Security related to cybersecurity, where they're going to start working together, and the exact extent of that is unknown. I do think it is a little bit troubling when you look at a survey that was taken late last summer on the anniversary of 9/11, where it found that 48% of Americans were okay with the government monitoring internet searches, and 55% were okay with the government analysis of financial transactions, and both of these without a warrant. In addition, 23% were okay with the government reading their emails without a warrant, and about 30% were okay with the government, 30% were okay with the government reading their emails without a warrant, and 23% were okay with listening to their phone calls without a warrant. And I think a lot of this, and including some of this empirical data that seems to suggest that younger people may have a different view of privacy, is that people do not understand the implications of what that means. Some people think, well, I'm not doing anything wrong, so I don't care if the government watches me. Well, let me tell you something. A, you may not know what wrong is, and B, you don't know how that's going to play 30 years from now. That's one reason in my classes I don't let them record them, because I don't want some kid in a classroom to say something in a classroom setting and have it thrown back to them 30 years from now when they're trying to be a Supreme Court justice or whatever. And the other thing is, I think people underestimate what can be learned by intelligence agencies from little scraps of information. You think those internet searches, well, they would know if I go to Al Jazeera, I'm just trying to, they can extrapolate all kinds of stuff. And from photographs, you would be amazed what can be learned from photographs and tracking. Imagine this scenario. Tracking GPS. People say, well, I don't care if the government knows where okay, you're driving along, it's driving rain, you pull over for a few minutes waiting till it's cleared, you stop, an hour later you go on. Well, you didn't realize it, but you pulled into the parking lot of a strip club. And so 20 years from now, you're going to try to be explaining why you pulled into that parking lot of a strip club. And if you think it can't happen, you're wrong. And it's amazing when the people who really know how to do this start focusing on like drone technology used domestically. We watched Sakari for 600 hours before we killed him. And believe me, a lot was found from that. I think people today really don't understand why privacy is important. And they don't understand why the Founding Fathers thought it was important. Why do you think the Founding Fathers even bothered with the Fourth Amendment? Well, partly because they were doing something illegal themselves when they were plotting treason against the crown. But I think it's more than that. Human beings, creativity and innovation depends on the ability of human beings to free think, to brainstorm. How many times in your own life have you said something to your friend, well, I'm thinking about doing this, and he or she says, what? Did you forget about Y? You know, you say you're going to do X, and they say, have you forgotten? Oh, yeah, Y. Yeah, oh, gosh, I don't want to do that. But imagine, though, in the future, if you're talking on the phone and suddenly that X proposal in your mind is preserved forever and thrown back at you at some later point. The point is that human beings need to be able to throw out ideas privately before they're ready to present them to the world. And you might think, well, I don't care if the world. Yes, you do, if you really think about it, because you have to fine-tune it. And if you start thinking, well, everything I do is going to be out in the public, trust me, you're going to start thinking differently. When I was in the military, I used to tell senior commanders, hey, you know, when you write your emails, you got to start putting some boilerplate in there in your own typewritten language, like, sounds like a good idea, run it by the lawyers, or get in the habit of writing, sounds like a good idea, but we need to do it by the book. Because I've seen in too many times in investigations where they will take out something out of context without that sort of qualifying language and saying, well, you approved, you should have known that was illegal or whatever it may be. And I'll never forget, there was a very senior Air Force officer who said, this is kind of a phrase that we often use, it's kind of sarcastic. It was along the lines of, the fun never stops around here. And that was drawn out from an email and thrown back at the guy during his confirmation hearing. He did not get confirmed. Well, you think that our investigation is fun, is amusing. It was taken completely out of context. So I think that if we are going to have innovation, if we're going to have free enterprise, people have got to have some way of communicating with each other and doing things without having to expect that that's going to be on the front page, that's going to be exposed to the world. Because if you don't, you're going to start changing the way people talk about chilling effect. It does have a chilling effect, especially because I think a lot of people now aren't really grasping what the consequences are. I've seen the consequences of just how disparate pieces of information can be put together into a larger picture that can be quite invasive if you're the target of it. So I think part of the answer, and I'm not sure what the answer is, I do think legislation is part of it. And frankly, I'm really glad I came to this because I really never zeroed in on the changing view of what a reasonable expectation is. And so I do think legislation, because a lot of times people don't understand the further implications. And so there's a lot for us to discuss, but let me go to my well-fed colleague next to me, because I'm afraid he might start taking a bite out of you if we keep him delayed.
So I want to pick up on that quotation from Justice Lee. Let me just remind you at least one of the things he says: dramatic technological change may lead to periods in which popular expectations are in flux and may ultimately produce significant changes in popular attitudes. So what do we do in the legal system when technological change is afoot? And what does it mean for constitutional rights? So one possible tempting answer is to say, well, the Constitution never changes. Okay, that's great as far as it goes. How far does that actually go? Because we still have to figure out, right, but how does the Constitution apply to some new technology? And you might want to say, think about this from the standpoint of judges. Well, judges should give answers that are not dependent on sort of these messy factual changes that happen. So first thing, one question, why do you think that's what judges should be? But also, we have the Article 3 problem. So Article 3 actually says you have to have cases and controversies. Judges actually resolve disputes. Federal judges, they do not opine ex cathedra. They are not up on Mount Olympus at 30,000 feet. They actually have concrete disputes before them. They are tethered to facts, and we expect them to be tethered to facts. In fact, they're constitutionally required to be tethered to facts. And by the way, back to my question of why we want otherwise. Would you really want 9 unrepresentative people who are sort of representing in many ways the dead hand of the past, who don't look like America in any meaningful sense, actually setting out the rules, capital R, that all of us will follow at some very high level of generality? I don't know why that would be normatively attractive. So A, I don't think it's normally attractive, but B, even if you think it is, it's just not consistent with Article 3 as we've interpreted. It's not consistent with the role that judges play. So for better or for worse, judges are in the business of having to translate how does this constitutional principle apply to this new technology. And you know what? It's always going to be embarrassing when there's new technologies that are developing, because first, judges are not going to be the leading edge of anything, and we probably don't want them to be the leading edge of anything. And so there is this danger of them writing things that then, not many years later, seem ridiculously outmoded. Now, part of what's interesting here is the Supreme Court has, on a few occasions, issued opinions that overruled earlier opinions where there had been factual change. It's actually never once, though, said that the reason it was reversing was because of the factual change. So 1915, the Supreme Court says there's this newfangled motion picture industry. It's not protected by the First Amendment. In 1952, they say it is protected by the First Amendment, but they don't actually suggest that it was a factual change. They don't really explain why it is they had that change of heart. I think it would be better if the Supreme Court were more honest about the role of factual change, which is part of what I like about Justice Alito acknowledging it here. It also actually happened in Ashcroft versus ACLU, one of the cases involving internet indecency, where the case there had been factual findings made by a district court, and by the time it got to the Supreme Court, I want to say about 20 months later, I can't remember exactly, Supreme Court says, among other things, we need to remand this because the facts upon which we're deciding may be stale. Things have changed a lot, and we need to remand. This is an issue near and dear to my heart, because I wrote an article about this, about in particular changing facts in the appellate process. What happens when there is a finder of fact that finds X, and then those facts later change? But of course, it isn't just limited to the appellate process. Also, as the article notes, any opinion is in danger of being outmoded because it rests on a set of factual assertions that no longer obtain. Whether it's technology or not, technology happens to be a particularly clear example of it, but it doesn't have to arise in technology. And this gave rise to this great quotation from Justice Scalia in the oral argument in an earlier internet indecency case. Here's what Scalia said in oral argument. "This is an area where change is enormously rapid. Is it possible that the statute is unconstitutional today, or was unconstitutional 2 years ago when it was examined on the basis of a record done about 2 years ago, but will be constitutional next week, or next year, or in 2 years?" Right? This is always going to be a problem for courts. There's simply no getting around it. And in fact, it's going to be a particular problem when we have tests like the Fourth Amendment test, reasonable expectation of privacy. That is, by definition, a test that is moored to a changeable sense of what you expect. But the point I'm making is, even if we had a test that wasn't so moored to that, we're still going to have the problem of technological change. There's still no getting around the difficulties that this creates. All right, so what do we do about that? So one possibility is we say, well, we want judges to do lots of updating. That might be a fine idea. It's generally, that's not how the Supreme Court sees its work product, right? You certainly could imagine that there would be a norm on the Supreme Court that anybody could sort of file a petition and say, hey, you decided that case based on a set of facts, and those facts no longer obtain, please reconsider that opinion. That basically doesn't happen outside of a couple of particular procedural contexts. It actually did happen in one significant First Amendment case, Establishment Clause case, but that was because there was happened to be continuing jurisdiction in that case. So the lower court did in fact say it was time to reopen because of new facts. But ordinarily, we're not accustomed to appellate courts doing that. Appellate courts we don't think of as engaged in this process of updating. And so, for better or for worse, there are lots of Supreme Court opinions that you read that have continuing significance, continuing precedential effect beyond the four corners of that opinion. They're taken to stand for a set of a bunch of propositions, and some of the facts on which they relied we would now regard as being stale, outdated, outright wrong, whatever. So a second possibility, of course, is Congress. Congress can move more quickly than courts, and it can update more quickly. It's also the case that it's very, very hard to get legislation through Congress. This is often referred to as veto gates. So you have the veto gate. You're really going to have to get the relevant committee chair in each house supportive. You're going to have to get the speaker, because the speaker controls the rules committee. You're going to have to get a majority of the majority party in the House. You're going to have to get a filibuster-proof level in the Senate and the president, or else an override-proof majority. It turns out it's really hard to do that. We think of, our civics class tells us it's 50% plus one. It's actually much, much more than that to get legislation through. So it turns out that Congress doesn't update as often as we might like. In my corner of the world, the Telecommunications Act of 1996 mentions the internet twice in the entire act, and has no clear provision of any regulatory authority over the internet, and spends all of its energy on the regulation of landline telephony. How many people in this room, by the way, have a landline telephone account? Who are not on this panel?
But
I see one hand back there. You have a landline?
I'm ashamed of it.
You have a landline telephone? Oh, all right. Anybody else have a landline telephone? All right. So anyway, that statute was enacted in 1996. It is universally regarded as woefully inadequate, and I am here to tell you that the smart money in D.C. is that it will not be revised probably until the next political cycle. So maybe the earliest it might happen maybe is 2015, but probably more realistically 2017, right? And there's something kind of remarkable about that. So what does that leave? It leaves agencies. Agencies can often move nimbly. Students in my administrative law class know, not as nimbly as they would have liked, and not as nimbly as they could have 40 years ago, but they can still move pretty nimbly. But we might think of them as being less democratically accountable, right? I'm guessing each one of you will find at least one of the last two presidents that you would dislike. So pick the one that you dislike more, and think what that president would do nimbly then, involving privacy or anything else, right? You might find this scary and prefer. Well, you know what? Pick your poison. None of these institutions is gonna do a wholly satisfactory job. Any institutions is gonna raise problems. Since we're short on time, let me just end by sort of returning to the underlying fundamental point. There is no getting away from this. When in a world in which there are new technologies, we could simply say we could try to have a blanket rule, and I think we would all regard it as sort of preposterous, right? So any new technology that is invented after January 1, 2013 shall or shall not implicate the Fourth Amendment, or any new technology that is smaller than a deck of cards. If 100 years they have decks of cards, is or is not. We can have kind of silly, bright line rules, but nobody actually thinks that makes any sense. And so instead, we are going to be in this world of changing technology and tests that will change in their application based on that technology, and especially so in the Fourth Amendment context where it's baked into the test in the first place. And with that, I'll desist for questions.
A hand in the panel. Being more afraid than I was and I was already very paranoid. And fascinating. Okay, questions from the audience.
Can I just make one observation
Yeah.
about what the people who said that they had a landline, you know how an intelligence officer would look at that? They'd assume, okay, she has an alarm system in her house, because most alarm systems, not universally, require landlines. And you see how a seemingly offhand comment will then get in a file. When we break into her house, we have to make.
No, you have to get by my dogs.
Yeah, there's ways of that.
I have a question. I saw an article recently that the FBI was soliciting anyone to build them a data aggregator of social media stuff. And I know the FCC was looking at something similar, just thinking, okay, there are some good things we could do here if we wanted to figure out that a pipe had burst or some other kind of crazy natural disaster had happened. If we could just see that a bunch of people in that geographic area tweeted about it or posted about it on Facebook last hour, we could send emergency crews there faster or something like that. Can you, do you think that that's something that's
Well,
useful enough that we'd have to figure out a way to
You're
fit that
raising
in?
an important point. You know, we shouldn't look at the FBI or NSA or anything with askance, because they're trying to increase our security. They sincerely want to do that. What we as a country have to decide is how much do we want to trade off and what is the cost? I would suggest that there is a psychic cost when you can't bounce an idea off of your small group of close friends without A, it being recorded for posterity, or B, being exposed to the world. That's going to change the way you think. And I think it's going to drive down innovation and creativity in this country. And it also undermines what I think is one of the great values of the United States, the ability to reinvent yourself. You know, at some point, you know, I know what you thought you did in high school was really amusing and so forth, but it may not be with the era. I worry about kids 10, 11, and 12 having Facebook pages and posting stuff on there and so forth, what the implications of that is going to be in the future. Because it is a great thing in this country that you can reinvent yourself, and that's going to be much harder in the future. Here's a crazy notion. I think that in the future, you will have, you know how you have like bankruptcy now, you declare bankruptcy? I think in the future, we may need to have something where we can declare our previous identity dead. I'm only half joking, and completely start with a new legal identity in which the slate is wiped clean, because I'm not quite sure how we can preserve the best things about American culture if we trade off too much in the interest of security. So I guess what I'm saying, you know, as tragic as it is, maybe it's better to have a few houses burned down or a few pipes burst and a few people, you know, there's this trade-off between security and other values.
Let me just push back on that quickly. I know it's quick, but so the question is, do we think those are American values, or do we think they happen to be values of a certain generation that are no longer attractive to others? And so we can look at them and say, wake up, you don't know what you're doing. And their response might be, hey, old fogey, I know what I'm doing. I actually am happy to make this trade-off, and this feels totally fine to me. And so, you know, this is always the question, is it feels like something is changing. It does feel like people are sharing information at a level that just seems remarkable, and that it actually is changing the expectations of privacy. And one of the interesting questions is, in effect, should we want the law to do something about that? Do we think that, let's imagine for purposes of the conversation that it turns out that we get a huge amount of information out there. So people actually do have a sense of what they're giving up, and they say, you know, I'm happy to give it up because my friends then know where I am, and I don't care the FBI knows. I don't know if you know, like there's a guy who films himself, who takes pictures of himself all day, every day, and he posts them online, right? Because he's in effect saying, okay, FBI, you want me access? Here's every meal I've ever eaten for the last 10 years, everything I've ever done.
He's exactly the kind of guy that FBI doesn't care about.
No, fine, but all I'm,
Yeah, no.
But my point is, there are in fact changes. Reasonable expectations are in fact shifting under our feet, and the question is, one way of framing the question is, what should the law do about it? Especially given that the law, to be blunt, is more likely to be made by and reflective of the value of people who skew a lot older than you all do, and whose value, and they may know better. Sometimes father knows best, and sometimes father's kind of clueless. And the question is, how do we want the law to respond to that?
I'm in violent agreement with you. My only concern is, do people really understand the implications of what they're giving up? I don't think they do. I don't think they have a clue as to how this information can be aggregated, used, and things determined about them. I think that they think they have more control over the implications of the information. Every one of those photographs that's posted online, you'd be astonished what an intelligence officer can take and find out about what you're wearing, what's in the background, color, everything.
I think the gentleman in the by the way, this event is being recorded, just FYI.
Well, I was just going to ask, with those hypotheticals of things getting thrown back at you, I feel like for me, it sounds like the problem isn't so much in people having too much information, but the problem is people making kind of faulty assumptions based on, or just wrong assumptions in most parts. And with, say, your strip club hypothetical where the guy pulls in, I mean, yeah, some kind of panel interrogating him could say, weren't you at a strip club because it was found on your GPS? But he could also say, yeah, but you could also tell from my GPS that I pulled in for 2 seconds and pulled out. And I just feel like I personally feel like norms are going to change. And take Facebook, for example, like we all have stuff from high school and college posted, and yes, people from an earlier generation might say, I can't believe you have this and that posted, but I sort of feel like norms are going to change in that, they have one embarrassing picture on Facebook. Who doesn't now, because we all grew up with it. So I understand what you're saying, but I also feel like it's not so much of a problem of people having too much information, it's more people making wrong assumptions.
Or right assumptions. Maybe you did something when you were in high school that you would not do today. And it's on Facebook. It's not in error or misinterpreted or anything like that. It's that it exists now forever. And I don't think that's the kind of society that we ought to have. Teenagers do stupid things, no offense to anybody. Is that what you have to live with for the rest of your life? I mean, and it's not just that. Even as adults, everybody gets mad, and they ventilate with their friends. And if that's preserved and recorded and the government draws accurate conclusions from that, is that the way we have to live our lives? And maybe it is a generational thing. I just don't think that the younger generation really understands what the capabilities are of data mining and data analysis. It is just unbelievable.
I take your point that those conclusions, if they do change, would
Make a difference. Mr. Renz,
So
surely one of those under 24s.
Sadly not. In fact, I'm old enough to remember as a very young student living in a surveillance state in South Africa during apartheid. And I knew that at least several of my friends, I wasn't a very important political player, but several of my friends were politically active, and I knew that their telephone conversations were likely to be recorded. In fact, back then the tech wasn't so good, it's certainly what we had in Africa, so there would be like a hum on the line that made you suspicious, and that chills your speech. You're 18 years old and you don't necessarily want to tell your friend about how this girl dumped you, even though you know the security police probably don't care, because somebody could be listening. This is personal stuff, right? So I agree that it chills your speech, and I think the idea that norms are going to change is very dangerous, because in the 1920s, for instance, the United States, it was pretty cool to be a communist. And then, in the 1950s, it was pretty un-American to be friends with people who'd been friends with people who were communists. And if you'd had the kind of, a lot of the time people ducked out of the House Committee on Un-American Activities, they got out because what? Because it wasn't a good record, so there was just a little bit of suspicion pointed at them. So I mean, norms can change, can bite both ways. So what I'd suggest is happening here is there's an asymmetry in the knowledge. Corporations, governments can gather a lot of data and information about people, and they can infer things with a surprising degree of accuracy. And the problem is you don't know what they're doing with it. So if a corporation is concluding, oh, we don't want to hire, or a law firm, we don't want to hire this guy because when we got all our reports, it says that, you know, every single time he spoke in class, he criticized the big companies whom we represent. Well, you don't know they're doing that. And so what's missing here is they've got information about you, you don't have information about them. If the intelligence agencies are inferring all kinds of things because you've got a landline, whatever you say on your Facebook page, then, and you don't know they're doing that. So it seems to me what's missing from this conversation is this concern about asymmetry. You might not be able to convince people politically that intelligence agencies have to give up and, you know, make explicit what the conclusion they're drawing about you. That's probably something you're not going to convince people. But what about, you know, increasing the independent oversight of those conclusions, or what people can do with that information? So I think part of this conversation should be about how do you counter this asymmetry? How do you say, all right, corporations, you say you say you think I'm pregnant. Let's see some of your stuff that you don't want everyone to know about how you're, where you're sourcing that, what was it, unscented body lotion. Oh, from this, sweatshop in Thailand. Well, maybe, you'll just...
I think it's still true of what Stuart said, that things do change, and expectations can change. I think the point that you're making, people need to make informed decisions as to what, a lot of people don't know that when you click off a Gmail account, you've agreed to let them read your emails. I've clicked off all kinds of stuff, which I did not read as closely as I probably should have. But I came from the military, and I just always knew that they were doing stuff like that. So, because I was in the military. But I don't know that I want the civilian world to live like that.
But also more transparency on the part of those who are gathering the data, not just about what they're doing, but what they're gathering and what they're doing with it. Yes, that would help the information asymmetry.
Can I just make two real quick comments responding to that? So there's Mark Rotenberg, who's the director of Epic. One of his big points is that the greatest civilian tool we have is FOIA, right? And that the Freedom of Information Act, for those of you who don't know what it is. So we actually have the ability to gather quite a lot of information about what the government is doing with our information, subject to national security limits. So I would say, FOIA, early and often, everything you can find about yourself from the government. And then I just, going to this information asymmetry, interestingly, in that empirical study I referred to, almost everyone, young and old, believed that there was a law in place that allowed you to learn what information someone had about you. I'm here to tell you there is no such law, okay? We really have no way of finding out what a third-party aggregator, data aggregator, what information they have about us. But I think that would be, in terms of leveling the information playing field, that would be an extremely important legislative tool for citizens to have.
I know we're out of time, but let me just say, maybe the most useful thing that I can contribute is there's an excellent news site, in case you don't know, it's called The Onion. And they had a great story about the enormous success of the CIA Facebook application.
Yes.
And that, as a result of the CIA Facebook program, now hundreds of millions of people have given their most sensitive material in a way that's now fully searchable by all the intelligence agencies of the world.
That's funny. We are out of time. I know Abby and Shira had questions. You're welcome to come talk to the panelists that still have time to stay. But I just want to thank the panelists for a wonderful discussion. That was
Produced by Duke University. Online at duke.edu.